This week, I studied employment law and discrimination. Employment at will. The employee can quit at any time for any reason, and the employer can terminate the employee at any time for any reason. The at-will doctrine is central to the employment relationship in the United States, but it is not necessarily the law in many other countries. Most employees in the US are at will. However, a number of statutes and judicial decisions have created exceptions to the at-will employment doctrine. As a result, the presumption of at-will employment can be overcome based on exceptions to the doctrine. These exceptions are based on contract, tort, and public policy theories. Contract theory. Courts have held that an employer may create an express or implied contract that strengthens the employee's job security. For example, an employer may state, either orally or written, that employees will only be fired or let go for good cause. Budget cuts or the employee's performance that negatively affect the workplace. Courts will look at a variety of factors when determining if the contract has been altered via this theory. The human resource policy is a starting point. Many HR policies indicate that an employee will only be terminated once the company has moved the employee through this disciplinary process. This process is evidence of the employer altering the at-will doctrine to one of good cause. Tort theory. This theory typically plays out when an employer fires an employee in a particular abusive way. Bringing a lawsuit based on tort is unlikely to get your job back, but being awarded a pile of money against your former employer may dull the pain. Public policy. The most common exception to the at-will doctrine occurs when an employee is fired for reasons that violate the state's statutory public policy. Successful suits based on the public policy exception to at-will employment usually involve similar patterns. These include the employee's refusal to commit illegal activity, the employee attempting to exercise a legal right, and performing an important public obligation. Child labor. The Fair Labor Standards Act created wage hour requirements for all employees in the US and is the basis for federal minimum wage laws. Children under the age of 14 are allowed to perform limited types of non-hazardous work, including delivering newspapers, agricultural work, entertainment, and working for their parents. Children ages 14 to 15 are allowed to work, but cannot work in hazardous conditions. Children ages 16 to 18 likewise cannot work in hazardous conditions, but are allowed to work longer hours. After turning 18, these limitations no longer apply. Over time, under the FLSA, many workers who work more than 40 hours a week are entitled to 1.5 times their regular pay for all hours over 40. These laws do not apply, however, to workers classified as executives, administrators, or professional workers. Family and medical leave. The Family and Medical Leave Act allows employees to take time off of work for family or medical reasons. It requires that employees give up to 12 weeks of unpaid leave during a 12 months period. it applies to workers that have worked for their employer for at least a year. The following reasons that employees can take the time off to care for a newborn child within a year of birth, to care for an adopted or foster child within 1 year of the time the child is placed with the employee, to care for the employee's immediately family with a serious health condition, if the employee suffers from a serious health condition and is unable to perform the essential functions of the job. Other workers' protections, workers' compensation. Every state has laws that provide financial benefits to workers that are injured while at work. Workers' compensation is an exclusive remedy, meaning that if an employee files a workers' compensation claim, she cannot later sue the employer for actions that led to injury. Unemployment insurance. If an employee is let go after working for a minimum amount of time, she may apply for state unemployment benefits. To qualify, workers must be willing and able to work and must be actively looking for new employment. Social Security disability. If a worker becomes disabled for any reason and is unable to work, Social Security disability benefits may be available. To qualify, claimants must generally show that they cannot work any full-time job on a consistent basis. Affordable Care Act, the ACA, also known as Obamacare, requires the medical and medium and large companies offer medical insurance to employees or face penalties. These employer mandates have been upheld as constitutional by the U.S. Supreme Court, but continue to be a contentious area of law. A majority element of the ACA, however, is that low-paid individuals may have their health insurance subsidized in order to take coverage more affordable. This is the summary of what I studied this week. Thank you very much.